If you pass away with no will in place, we call that dying intestate. And in that situation, state law fills in the gaps. In other words, everyone has a plan, but for those who don't plan for themselves, the state has planned for you. So in North Carolina, a clerk of court has to appoint a personal representative to pay your debts, file your last tax return, and distribute your assets without any guidance from you about who you would like that person to be. And if you leave a mess, they have to deal with that mess. State law dictates who gets your things if you haven't clarified in a will who your heirs and beneficiaries are and what you would like to do with your assets. State law mostly tends to follow kind of what you would expect people to choose, but North Carolina does have some funky rules. Most people assume that a surviving spouse gets everything automatically. But if you own any assets individually, a spouse may have to share with your parents if there are no children. And if there are children, the amount the spouse inherits may depend on whether there is one child or two or more children. They don't care if the child is a minor or a stepchild to the surviving spouse. And if there's no spouse, no children, no grandchildren, etc., then it goes up to your parents or even your grandparents' generation to find your heirs at law. That's your closest living relatives. So even though North Carolina law does fill in the gaps to make sure that people who are close to you receive your estate, it might be different from what you'd like. And the laws also don't clarify who's in charge of the assets left to a minor or an incapacitated beneficiary. A guardian would have to be appointed to raise the children with no input from you, and a custodian would be put in charge of the assets for the minors. Your children would get the entire inheritance without any protection from creditors, predators, bankruptcy, divorce, and poor decisions as soon as they turn 18. The custodian would have to give the court an annual accounting, even if it's the child's other parent. So state law doesn't do a whole lot to make sure that those who do receive your assets receive it in a way that you would want, in the amount you would want, and maybe at the specific ages or stages for your children, whether under 18 or not. So as you can see, it really is important to make sure that your own plan is laid out in a legal writing, so you're not having to rely on state law, which can cause a lot of stress, conflict, and legal problems for your loved ones. Watch my other videos to learn more, and to discuss your particular situation, schedule a complimentary call today.